Mhm.
Good morning. Are you Mary Robinson?
Yes, ma'am.
Ms. Robinson, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion?
Sure, yeah.
Ms. Robinson, in cause number 24, BCCR 1116, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 2nd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am. I thought it was 5 years.
Looks like it was for 10 years.
They told me it was 5.
It was originally a cap of 5 years.
Okay, so you had a cap of 5, but instead of me sending you to prison for 5 years, I gave you 10 years probation, which is what I'm allowed to do. The cap of 5 years just had to do with prison. And since I didn't give you prison, I gave you a longer probation back at that time. And we talked about that back then, and you went over the paperwork with your probation officer. Do you understand? Do you remember that?
They gave me 5 years.
I gave you 10 years deferred probation. So if you're confused about that, then now I'm telling you, you have 10 years deferred probation that started on December 2nd of 2024. Okay?
Mhm.
All right. So this motion alleges that your probation was violated. It's count 1 alleges that you violated by failing to report as directed.
I did.
Listen, it's real important that you listen to what I'm asking you, and then I'm going to ask you if these things are true or not true, okay? And that's all. We'll have the explanation later. I'll give you an opportunity to explain later. Count 1 alleges that you failed to report to the probation office as directed October 7th, November 13th, and December 18th of 2025. And is that true or not true?
It was on the. I'm sorry. What you say?
So it was October 7th, November 13th, and December 18th that you did not show up.
No, I was supposed to report December. I think it was the 22nd. I showed up like the 20.
Did you report on October 7th?
No, I went like October the 20s. I want to say it was the 22nd because
So if you didn't listen, if you didn't go on October 7th, it sounds like you were ordered to go on October 7th and you didn't go. Sounds like you were told to go on November 13th and you didn't go. So did you go on October 7th?
This March, I went.
Listen, Miss Robinson.
I did go. I went.
Listen to my question. Listen to. Hold on. Do we need to?
I think that there may be an issue, if I may, Your Honor, of her being medicated or not in jail. Ms. Mayfield can speak to that if it would help. I think it's like we're dealing with maybe 2 different individuals when she's medicated and when she's not. Do you have additional to add to that?
Right. Would you raise your right hand? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead.
She was placed on my caseload, which is the mental health initiative. She was attending Spindletop. She was reporting as directed up until she started missing her appointments with Spindletop.
Okay. So what is the recommendation?
I would like for her to be placed, go through the forensic program, and I work hand in hand with them. So if I need to go to the appointments at Spindletop or communicate with the caseworker, I'm able to. So my recommendation was for her to go through that program, take medications as directed, and be placed on 0 tolerance.
So, Ms. Robinson, it sounds like for a little while you were going and doing what you were supposed to do with Spindletop.
I went to probation on the 22nd. I got a letter. It's supposed to be on the 24th.
Right. So listen, what about Were you going to Spindletop?
I'm not going to Spindletop. I'm going to get a job. I got children.
So here's the thing. If you're going to be on probation, a condition of your probation that's required is that you go to Spindletop and go through the forensic program, take medication as directed, and go to any meetings, any counseling, anything. If you don't do that, then you're going to go to prison. You don't have a choice.
I understand, but I need a job.
I would love for you to have a job, but you have to
because my life got cut off, and I honestly was in the streets trying to find out what my children is because I'm just like that.
Okay. So here's the thing. Are you willing to follow the directions and go to
a job? Like,
I'm not talking about a job. I'm talking about going to Spindletop and getting on your medications and doing what you're supposed to do so that you can get a job.
Yeah, I need a job like right now because
I need you to go to Spindletop. Are you willing to do that?
Fine.
It's not, is it fine? Are you willing to follow those rules? I feel like we're going to be right back here.
I was just inquiring if Ms. Mayfield, judge if ISF cognitive might be able to regulate her medication. I don't know their procedures on dispensing
I
medication.
don't know if, I think the only special needs safety, I know, addresses that, but I don't think ISF cognitive does. No,
No.
I didn't think so.
Right after that structure, we're just right back here on the same thing.
So do you have a place to live when you
Yes,
get
ma'am,
out?
I do. I was going to get a job. I'm trying to get a vehicle. I need to go straight to work because, like,
You've got to go straight to probation and straight to
Yes, ma'am.
Spindletop.
I did. It's just that they told me she was in court, so I had to be understanding, and I had to walk out.
But you stopped going to Spindletop. You were going and then you stopped.
Because I feel like I need to go get a job. I don't want to be like,
You can't do that though. If you don't go to Spindletop
Yeah.
and if you don't do what probation tells you have to do, then you're going to be back in front of me and you're going to end up in prison.
Yes, ma'am, I understand.
There's no other option.
Yeah.
You don't get to choose whether you go or not at this point. Do you understand?
Yes, ma'am, I understand.
So I guess what we can do instead of going through, she's obviously didn't comply with Spindletop. I'll find count 3 true just based on the evidence presented today. Let's see, from probation, you're sworn in as well. Did she report October 7th, November 13th, and December 18th? Okay, so I'll find count 1 true, count 3 true. That's enough for what we need to do here. So, Ms. Robinson, what I'm going to do is find count 1 and 3 true in your motion to revoke.
Yes, ma'am.
I'm going to find that you didn't show up when you were supposed to and that you didn't follow through with Spindletop like you were supposed to.
Yes, ma'am.
What that means is right now today I could revoke your probation and send you to prison. But it sounds like probation doesn't want that. Nobody wants that. I don't want that.
Yeah.
But we want you to be successful. So I'm going to continue you on probation.
Okay.
But I am ordering that you will go through the forensic program through probation and required to follow through with Spindletop, take any medication, any treatment, counseling, whatever they say, you have to do it. I want you to get a job as well, but you have to make your mental health first because then you'll be able to get a better job and do better. Does that make sense?
Okay.
Okay. So probation will talk to you as soon as you're released from custody. Go to probation so you get the track, get those appointments, and so that you're not back in here. Because if you don't, and you refuse to go to Spindletop and you don't show up for your appointments at probation, you're going to be right back in here and I won't be able to give you this opportunity. Okay?
I understand.
All right. You can go back with the bailiff.
I understand.
Good morning. Are you Samuel Harmon?
Yes, ma'am.
And Mr. Harmon, in cause number 25 DCCR 1019, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 3rd of 2025. Your indictment alleges that you were previously convicted of evading arrest or detention with the use of a vehicle, a third-degree felony, March 30th of 2016. And then after that was final, you were convicted of the third-degree felony offense of tampering or fabricating physical evidence with the intent to impair from March 11th of 2020. And what that means, sir, is that if you go to trial and you're found guilty and those prior convictions are true, you would be considered a habitual offender, which means your minimum punishment would be 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain here that you've signed with Ms. Holmes, and it had marked off the second-degree felony range of punishment, which is what the punishment is for your underlying offense. I've made the notation on here that I have admonished you with regard to the habitual offender punishment if you're found guilty. And so this shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes.
And Mr. Nichols, is there any reason to believe that would change? The
No,
offer
Your
would
Honor,
change?
that's off the table at this point.
So I want to make sure you understand, Mr. Harmon, that after today, I will not accept this plea agreement. Mr. Nichols has taken it off the table. Once we put your case on the trial docket, it's expected to go to trial, or you can plead either open to the court or to something different other than this. Do you understand?
Yes.
All right. And so, Mr. Harmon, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and I can appoint another attorney today who can begin preparation for trial a little quicker. Is that okay with you? All right. So, Ms. Holmes, you're released. Mr. Harmon, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right. You can go back with the bailiff. Good morning, sir. Are you Daryl Sneed?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Sneed, in cause number 25 DCCR 1800, you're charged with a second-degree felony offense of burglary of a habitation from April 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
Thank you. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sneed is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's...
His criminal history is very limited, Your Honor. I have no objection to a bond pending sentencing.
Okay. And so, Mr. Sneed, what I'm going to do based on the nature of your plea is reduce your bond to $1,000. I'm going to make a condition of that bond is that if you cannot have any contact or be around or go to the habitation of Billy Davis. What is that address?
595 Ashley.
2595 Ashley. So you cannot go anywhere near that location. Okay. That's part of your bond if you make it. If you make your bond, then it's one of the first things you do is go to probation so they can start that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. If you're arrested for anything between the time you make bond and come back for sentencing, obviously I don't have to accept the agreement and things could be worse. And then finally, if you violate that condition of your bond and have any contact with or are around the address that I just stated, then you obviously run the risk of me not accepting the agreement. Do you understand? All right, we'll see. Yes,
I'm
ma'am.
sorry. Mr. Sneed wanted me to ask if the court would consider a personal recognizance bond.
At this point, because of the nature of the offense, I want to make sure that there is some bondsman. It's as low as I can make it at $1,000, so that if he makes that bond, at least there's someone making sure those conditions are being followed.
Yes.
Based on the nature of the offense. Okay. All right, you can go back with the bailiff.
In this courtroom hearing, the judge handled 3 different criminal cases. First, Mary Robinson faced a motion to revoke her 10-year deferred probation for aggravated assault with a deadly weapon. The court found that she failed to report to probation on several required dates and also stopped attending the Spindletop mental health program. Mary explained that she needed a job and was trying to take care of her children, but the judge told her that following her mental health treatment and probation requirements had to come first. The judge could have sent her to prison, but instead decided to give her another chance. She was ordered to complete the forensic program, attend Spindletop, take her medication as directed, and follow all treatment and probation requirements. The judge warned her that if she failed again, she could return to court and face prison. The second case involved Samuel Harmon, who was charged with aggravated assault with a deadly weapon. Because he had 2 previous felony convictions, the judge explained that if he went to trial and was found guilty, he could face a minimum of 25 years and up to 99 years or life in prison as a habitual offender. The prosecutor had offered him a 15-year prison sentence through a plea agreement, but Harmon rejected the offer and chose to take the case to trial. The judge warned him that the offer would no longer be available once the case was placed on the trial docket and then arranged for a new attorney to begin preparing his defense. The final case involved Daryl Sneed, who pleaded guilty to burglary of a habitation. His agreement called for 5 years of deferred probation and a $500 fine. The judge accepted his guilty plea but delayed final sentencing so probation could prepare a pre-sentence report. His bond was reduced to $1,000, but he was strictly ordered to stay away from the victim's home. The judge warned that violating the bond conditions or committing another offense could cause the plea agreement to be rejected and lead to a harsher outcome.